I'll try that again with microphone on. I'm Ken Koenen. Thank you for joining us today. We're going to be talking about wills and trusts and estate planning. Um, Before we go any further, just as a kind of a housekeeping thing, I'm an attorney licensed in the state of Arizona and California. So if I'm talking about legalese, any kind of a legal matter, I'm talking only um, based upon Arizona and California law. So if you're from out of state, when you're looking from out of one of those two states, I'm not giving you any legal advice. But generally, all of these things kind of match in most jurisdictions. So this is one of those topics that nobody likes to discuss, death and taxes. And unfortunately or fortunately, um, taxes and death go hand in hand sometimes. So let's get right into it. Um, Understanding wills, trusts, and estate planning. So our first thing that we have to know is what exactly is an estate? Well, an estate is pretty much everything you own, whether it's a house, money, cash, uh, jewelry, insurance policies, stocks and bonds, even your IRAs are a asset and then part of your estate. Now, why should people do estate planning? Well, number one, after you pass away, you can control who receives your assets, plus pay the minimum legal fees and taxes that could be required. The other issue is if you become incapacitated, somebody else might be able to control your assets and make your medical decisions uh, by going to a court and getting an order. So who needs estate planning? Well, basically everybody. You can be older and on the verge of retirement or already retired. You could be a family with kids, without kids, or even single, because you want to be able to control what happens not only to your assets, but to your life if something should happen to you before you pass away. Examples of what can happen without a good estate plan is Lou Reed, when he died, his estate was worth $30 million dollars, and he had about $4 million in debt because it's a lot of money. There's a lot of legal fees and executor fees, and usually some fighting when there's that much money. So that cost was over $4 million dollars. And then he had another $9.5 million almost for estate taxes, which meant about $12.5 million went to his heirs. Groucho Marx was declared incompetent. He lost control of all of his assets, personal decisions, privacy, and then the costs were all borne by his estate. On a more modern example, I just read a few days ago that Buzz Aldrin, the astronaut, his family is trying to have him determined to be incapacitated. So you need to, you don't really want that to happen. So when should you plan? Obviously, it's now while you can do it. Uh, you don't want to wait until you need it because then you can't do it. I've got a case right now where a lady uh, is now suffering from dementia, and her husband never did anything, and we have to go through court to get a conservatorship. And believe me, there's no second chance. Once something happens like that, it's there's nothing else you can do. Then you're just depending on the courts. So these are some supposed common estate plans. Of course, do nothing is the worst. Um, Writing a will is better. Joint ownership of property, so to be right of survivorship. Uh, Give away your assets. Transfer on death. When you've passed away, you transfer that those um, your assets when you die. And there's also the revocable living trust, which we'll be talking about in great extent today. So this is plan 2, but this is really plan 1. When you do nothing, basically your estate goes through probate. Assets are distributed according to the state law. Generally, that means if you're married, the spouse will get a certain amount, your children will get a certain amount. If you're not married but you do have children, they get each a share, an equal share. And maybe that's not what you decided that you wanted. Maybe one of your kids was a real jerk. But anyway, that's one of the things that you just can't control if you don't do anything. And if you become incapacitated, you have an accident, you're in a coma or something, the courts can then control all of your assets. So what is probate? It's basically a legal process where if you have a will, it's being validated, all of your debts are paid, and assets are distributed according to the will. And it's the only legal way to change title of most property, such as real estate, automobiles, things like that. And probate is it's a process. All of your assets go into a funnel, basically, and you go through time and the probate hearings and all of that, fees, taxes, and then whatever's left over goes to your family. Now in California, probate is very, very expensive. They have a fee structure that's by statute. And the first $100,000 of an estate, the fee for probate is $4,000. The second 100,000 is 3% or $3,000. And then the next 800,000 is 2%. So that would be 16,000. Now, that means a $1 million estate, which is not hard to do in California. There's areas where the median price of homes is $1 million, would be $21,000 in fees. And that's just to the executor or administrator. If there's an attorney used, that attorney receives the same fee. So it's $42,000 that's going away. Then there's probate fees, appraisal fees, and other fees. And the reason this happens is because nobody planned. Arizona probate fees are a little less defined. They're based upon what an attorney work is actually done. There's a couple of processes in Arizona that are a little faster than California, but it still is a lengthy process. But as in California, there can be filing fees, appraisal fees, and all the other things. And again, it's because nobody planned. Probate's a big business. $1.5 billion to attorneys and billions more to appraisers, bonding companies, and the probate courts. And it's a long process. It can take anywhere from, it's not quite as bad in Arizona, it can be about 6 months. But in California, it could be 9 months to 2 years. And of course, there's always the possibility of people fighting over your assets. And finally, there's no real privacy. Everything is public record. So an inventory can be filed and anybody can go to the court and have that file pulled and go through it. And they're easier to contest. And basically, the probate process controls everything. How they interpret your will, costs, privacy, and the time that's involved. So now the other method of estate planning is to write a will. And what it does is it controls assets that are titled in your name, and it expresses your wishes, but it's still enforced by the probate court. A will does not go into effect until you pass away. Again, it's a time consuming. Um, and if you become incapacitated, a will doesn't help because, like I said, it doesn't go into effect until you pass away. So while you're alive, if something happens to you, then somebody has to go to court, get a conservatorship, um, whereas that can be easily rectified by having a power of attorney beforehand so you can name somebody to do these things for you. Now, wills and minor children, what happens now is if you have minor children, the court can appoint a guardian for those children instead of you appointing a guardian. The will do that, and it'll also help that person control the finances of the child. But once you pass away, if you have a minor child, that child inherits everything once they hit 18. Now, joint ownership is usually when you have a husband and wife and they jointly own property. It can be joint tenants. Tenants in common is not joint ownership. It's each person has a 50% ownership. Joint tenants means they have a right of survivorship when one passes away. The other gets all of the assets that are jointly held. There's also in community property states like Arizona and California, there is community property with right of survivorship. But what happens if something along this line takes place? So Bob dies, Bob and Sally are joint owners. Bob dies and Sally automatically gets Bob's share of the house. But then Sally dies and the heirs of Sally now inherit. That would be their children. But what happens if after Bob dies, Sally ends up marrying Tom? Maybe they were younger, and then they commingle their assets, and then and Sally dies. Then Tom inherits Sally's share, and the kids from Bob and Sally can be disinherited. And this is a terrible thing to have happen when you're not planning. So it really only postpones probate because eventually that second person is going to die and that the estate still has to go through probate. There can be accidental disinheritances. Again, incapacity does not help, is not taken care of. If there's a co-owner on property like that, then it's hard to get them off. And you have lawsuits, debt, and tax problems as well. Now, you could just give away your assets. You're getting old, and you say, well, I think I'll just give all my stuff to my kids or whomever you want to give it to. But what happens is you lose control of your own assets. They now have control of everything. But they also will miss out on the step up in basis. And I'll give you an example of that. Let's say they have a house, there's a house that's owned that's worth $700,000 and it's been owned since day one. They bought it for $50,000 20 years ago. Well, there'd be capital gains of $650,000 to the heirs when the person who gave the property away died. So now there's $100,000 to $150,000 in capital gains tax. But what happens if it's transferred at death? Well, then under IRS rules, the basis steps up to the value of the property at the time of death. So then they can sell the property for $700,000 and there's zero capital gains and zero capital gains tax. That's a lot of money to be not giving away, $100,000 to $150,000. So then you have the possibility of transfer on death. Not every state has that, and it's basically a deed where it says when I die, this is for a real property. When I die, my heir becomes the new owner. But the problem with that is what happens if that heir dies first or you die at the same time? You don't have any contingency plans. But that's just something you don't really want to do. And again, you don't have any control over your minor children. And there's a whole different meaning to what's my estate. So the other plan, which we're going to talk about at length, is a revocable trust. And basically, you keep control of all of your assets and you keep control of where you want them to go, and you keep them out of the probate courts. So what is a trust? It's basically a legal entity where the right of using the property is held by one person and the title is held by another, even though they're the same in most cases. So the one person is the trustee who is actually holding the title to the property. The settlor is the person who put the property into the trust, and usually in the beginning, they're also the trustee. And then finally, it's for the benefit of a third party, which could be their spouse or their children later on. Now, it has to be valid, it has to have specific property, and it must reflect the intent and be created for a lawful purpose. So if you have a illicit drug dealership, you can't put that in a trust and leave it to your kids. So now the difference between wills and trusts, well, they've both been in use for hundreds of years. They both name somebody else to handle your affairs. In the case of a will, it's the executor. In the case of a trust, it's the successor trustee. It names who you want to have receive your assets when you pass away. They both do that. A will will not avoid probate like a revocable living trust will. And it also avoids the living probate, which is while you're still alive, the courts can decide what to do with your assets. Because when you're incapacitated, you don't really own the property. The trustee or successor trustee is in charge. So what do? We change title from the way it is now to your living trust. And the way that's done, in most cases, if you have Bob and Mary Smith, we change the title to your property to Bob and Mary Smith as co-trustees of the Bob and Mary Smith Trust. And there's nothing to probate. So probate fees are gone. Taxes can be reduced or eliminated if it's done right. And your beneficiaries get the bulk of your estate. Plus the time is much shorter because you don't have to go through hearings. You don't have to wait 4 months for the final order to come through from the probate courts. And you keep control of all of your assets. You can buy and sell just like you did before. You can cancel the trust or change it. And it just contains all of your instructions in writing. And this is just, again, a little step by step. We have the grantor, which would be you, and you create and control the trust. The trustee manages the trust, and that is normally you as well. And then when you pass away, you have the successor trustee who then steps in for the trustees. And then finally, that person's job is to terminate the trust by delivering the assets to everybody who is named in the trust after paying all of any debts or taxes that might be owed. Now you can also get, if you don't have anybody who really wants to be your trustee, there are corporate trustees Some are very large, and they only deal with, five, six, $10 million estates. But there's some local smaller companies that are licensed fiduciaries. They've been approved by the state, and they can act as your trustee if you have nobody else. Plus, you control the inheritance. Um, you can do it all at once or in installments, only the income. So, for example, there was a story of a guy who was quite wealthy. He was in the dot-com boom era, and he had about $5 million. He was divorced. He had no will, no trust, no anything. He had one child, age 13, who basically inherited his entire $5 million. Now, he doesn't get it right away. It's held in trust until he's 18. Now, he turns 18, and all of that money comes to him. Now, he's got two choices: go to college or go to Paris. So, what's he going to choose? Who knows? You can control this by setting an age limit, allowing only income, or maybe paying it in installments, like 1/3 when they hit 22, and another third when they hit 28, etc. And you can also have situations where you might have a special needs child, somebody who has a mental handicap or something like that. And you'll want to set up a special needs trust that will never go to that person, so they can continue to get supplemental income from any federal or state sources. Now, estate taxes are not a big concern anymore. For a couple, it's the exclusion is $11,150,000. So you'd have to have a relatively large estate, and anything over that is taxed at 40%. So, but estate taxes, even if you have that type of a asset base, estate taxes are still optional, because we can establish different types of trusts that or ownership in different ways that will reduce the value of the estate to under this $11 million number. So let's talk about the summary of the living trust. Basically, it avoids probate when you die, prevents court control of assets if incapacitated. And the reason that happens is we have a clause in the trust that says if you are incapacitated, and that's been confirmed by two doctors, then there's no, the successor trustee takes over. So you don't have to worry about somebody else taking over your assets. It gives you maximum privacy because none of this is available to the courts or the public unless one of your relatives tries to contest it. What we always say here is where there's a will, there's a relative. But it also increases the distribution of your assets to your beneficiaries, and the assets can stay in trust until you're ready to have them delivered out. And it also prevents what we talked about earlier, that accidental disinheritance of children, and it reduces or eliminates estate taxes. Now, we also always prepare a durable power of attorney, which basically says that you have named somebody who is going to take care of your business assets and business needs if you are incapacitated for any length of time. So you don't have to go, nobody has to go to court to become a conservator. Um, they're allowed to conduct business for you, only goes into effect when you're incapacitated, and it specifies exactly what powers they can exercise on your behalf. You also will have medical decisions. You want people to have a healthcare directive so you can write out exactly what it is that you want to have happen. Do you want the plug pulled? Do you want somebody else to be made aware? We have these HIPAA regulations that will not allow doctors to release information to just anybody. So the Advanced Health Care Directive gives a HIPAA release so that the person that you want to be able to speak intelligently about your wishes can know what's happening. There's also in Arizona a mental health directive, and we have a living will, which basically says whether, if you are in a coma or you have in a vegetative state or you have an incurable disease, what you want, how far you want your doctors to go. You want them to just not give you any food, don't resuscitate, things like that. So you're controlling what happens. So if you don't want to, if you don't want the lack of quality of life, then this is how you get through it. So basically there's 5 steps to, saving your estate and your family. And that's basically write down what you want to do. What would you want to have happen to your income or to your assets if something did happen to you? Make an inventory of all those assets that you have. Some people just don't realize the value of things that they have. Get a professional to help you and have your legal documents prepared. And then once that's done, you get your assets changed, the title changed to you as trustees of your trust. So a typical estate plan is a revocable living trust, certification of trust, pour over will for both parties if it's a couple. Basically a pour over will simply says any asset that I have not effectively put into my trust, I'm leaving it to my trust to be distributed according to the terms of the trust. And the pour over will is also where you name a guardian for minor children if you have any. And then we have the durable power of attorney. We talked about that, where somebody can do business for you. It's very important that you make sure that it says when you become incapacitated, unless I've seen power of attorney that are basically limited to signing a deed or a loan on the house because one person is in the new town and the other person isn't. So they'll get a specific power of attorney just for that transaction. With a durable power of attorney, you want that only to go in effect when it's been deemed that you're incapacitated. Then, of course, the healthcare directives, the mental health care directives, and the living will. Now, because there are times where I said there's a will, there's a relative, there are times that people will come out of the woodwork. I had a case where I had to testify because this young lady who had not spoken to her grandfather in 12 or 15 years and lived in another state. When he died, all of a sudden, she had tears streaming down her face and challenged the documents that had been prepared. So I had to go testify in court and basically convince the judge that this guy was not Looney Tunes or under any duress at the time he signed these documents. So especially in situations like that, I video the signing of documents and I ask questions so that people can see that the people signing are of sound mind. There's nobody holding a gun to their head, that they did everything um, on their own free volition, especially if somebody's being disinherited or receiving a smaller amount than someone else. Now, there's a lot of, you'll see ads for document preparers. Um, a document preparer is basically somebody who's um, been registered with the state in some cases, and they'll prepare documents, but they cannot give you any kind of legal advice. So the basic difference is like I said, the certified legal document preparer cannot give you legal advice, opinions, or recommendations. Well, that's what you need sometimes. They have no protected or privileged communication with you. In other words, if somebody was to sue somebody and regarding, sue you or sue somebody else, and it had to do with you, they could not bring an attorney like myself into court to testify about anything that we've talked about. Whereas a document preparer does not have that privilege. He also can't help you if you're already being represented by an attorney. And there's a number of things that they have to do. And I just, basically what you get is a cookie cutter document made from software where an attorney can provide you with an estate plan that precisely meets your needs and those of your family. We can put in clauses and make recommendations that a document preparer just cannot do. And you'll also see seminars sometimes saying, we'll do your trust for, this was really big in California, we'll do your trust for $499. And the reason they chose that amount is because $500 would have been a felony. There oftentimes they would run these, they would say that we're going to have this seminar and it's going to be taught by expert attorneys on estate planning. But then you'd see an ad in the legal newspapers saying, we need attorneys to give this presentation, no experience required. In other words, they're going to teach you what to say. And generally their real purpose is to sell you things like annuities. So, and they're just going to give you a kind of a cookie cutter estate plan as well. So, if this is something that's of interest to you, I would love to have you consider us. As I said, I'm an attorney. I also have a real estate broker's license in California, so I'm very knowledgeable on both real estate as well as estate planning topics. And you receive the full estate plan, which the original, we recommend that you keep it in a safe or in a safe deposit box, and then we'll give you a copy, either a hard copy or a electronic copy on a thumb drive, so that you can reference it when needed. So for example, one of your kids gets you mad, maybe you want to see, what did I leave little Jimmy here? So that's that's why you have the second copy. And then, like I said, we video record the signing and provide a copy of a DVD for you, and we retain one in our safe in case you lose yours. So the key here is to relax and enjoy life and know that your loved ones are cared for. And we'd appreciate an opportunity to be of service for you. The biggest, one of the nicest compliments that we've received not too long ago was a client we did an estate plan for, and they were under some duress as far as one of them was very serious, had just been diagnosed with a rare form of cancer. And we bent over backwards to make sure they were taken care of as quickly as possible. And the comment from the spouse, Mrs., was that she appreciated the fact that we were so human. And I really take that to, I'm real proud of that, because that's what we are. We're not a big stained glass 20 attorney law firm. I just take care of my clients. So we'd love to hear from you. My phone number is 623-888-6340. And I do a number of other areas. I do taxes, estate planning. I do tax preparation as well as tax issues. I help with real estate investments, in self-directed IRAs, probate, wine law. That was more from California, and that does not mean I'll work for wine. And I also do mediation. So again, 623-888-6340. And if you're watching this on YouTube and you would like to see more of these, because I'll be doing a number of videos on different topics from taxation and real estate, sometimes a little bit of political commentary based upon what's going on today and how the laws are affecting everything. So if you enjoy that kind of stuff, you're watching on YouTube, I think you can go down to the bottom there and hit the subscribe button. And we'll look forward to hearing from you sometime in the future. And once again, thank you very much for watching. I'm Ken Koenen, and we'll be happy to help you. Have a great day.